My name is Sayed. I am the chair of the law department at the School of Global Affairs and Public Policy at the UC. I would like to welcome you to this exceptionally beautiful evening, despite the difficulties of traffic, which we have no problem with whatsoever. Especially we're having with us today a renowned expert and an illustrious jurist, Dr. Pekka Hallberg. For the past 40 years, Egypt was going through a constitutional turmoil. Which is basically an important turning point in the constitutional history of Egypt since 1923. And at the same time, as unique and as powerful this experience is, it is also an experience that many countries around the world have gone through over the years. And we are very lucky to have somebody like Professor Hallberg, who actually have gone and engaged the local context in so many settings to come and give us a perspective to help us make sense of all these developments and changes. Dr. Hallberg is very well known in Finland, but also for anybody who's interested in comparative constitutional law and rule of law reform. He's a very well-known name. And the only thing that I would like to say that in Finland, before starting his role as a global expert, if I may say so, he was the President Emeritus of the Supreme Administrative Court in Finland. And I must say that over the past few days, our interactions have revealed to me to what extent it is important to always engage different systems and different ways of looking at law from different cultural perspectives in a way that makes us appreciate what's unique about our situation, but also imagine solutions that we think are impossible. Before I leave the floor to Dr. Hallberg, I would like to ask Ambassador Yuriola, very grateful that she was helping us all throughout in making this event, to come and say a couple of words of introduction. So thank you.
Thank you, and I must say that I have to immediately turn the thanks around because without the AUC's Global Affairs and Public Policy, and especially the Law Department and Dr. Hanisai, we would not be here today. Perhaps Dr. Hallberg would be here, we would be having all kinds of interesting meetings, but not this kind of a possibility to have him give his ideas on both related to constitutions, I could almost say, and to the rule of law, but also to hopefully have a good exchange of views and Q&A after his presentation. I think that I will certainly not take too much time, but I think I want to say that the reason why we originally thought of inviting Dr. Hallberg here in Egypt is I had the pleasure of working in my previous capacity as ambassador to Central Asia with him in a number of Central Asian states where he was doing this kind of, let's say, comparative dialogue, and then also came up with a book with some certain observations and so forth. And I thought that I learned so much from him during these travels that I wanted to share his wisdom. Also here in Egypt at a time when there is a new constitution here, we are waiting for a new parliament which will be implementing the constitution through legislation. And I thought that this is in fact the perfect time to have this, let's say, beginning of a dialogue, hopefully, on these issues. And since I know that he has this vast international comparative experience on these, and of course also, and especially experience from the Finnish constitution, which he has been working to amend, then it's quite interesting to look into these, comparatively to all these issues. And I will certainly let him elaborate on that, but his way of looking at what the rule of law is something that has certainly enlightened me. Me not being anything close to, I have never had any training in that field, but learning a lot from that. So I would really just like to thank everyone for coming, in particular, since I know that there might be some traffic problems and probably some more people will come in as we begin this. But thank you on my behalf, and I think I will really rather now leave the floor to the person who really knows what he's going to talk about. So thank you very much.
Ladies and gentlemen, esteemed audience, it's a great honor and pleasure to be here in Cairo, in Egypt, fabulous country, especially for us Finns. I will explain that later a little bit. But before that, my thanks go to, of course, American University and Professor Hani Sayed and our dear Ambassador Tuula Yrjölä, who organized this meeting. Let me also say that we have met, my wife and I, so exquisite hospitality that we feel like real diplomats here on the diplomat group. My explanation why Egypt is so fabulous country, just as Finns, is that maybe our most famous Finnish author, Mika Valtari, has written a book, Sinuhe the Egyptian. He was a medical doctor and lived about 3,000 years ago. He was a quiet, philosophical person, and I would follow Sinuhe's way, and I'm more listening than having any messages, because you are much more experts in Egyptian constitutional reforms than I would be, and I really enjoyed the discussion we had yesterday at the university with young students. Young students, they mean the future. Let me start by saying that, of course, Egypt is also among the other reasons, the region's predominant country, focus of special interest, and gives us researchers some perspective on development of democracy and constitutional reforms. We also know, we outsiders, that the Arab Spring brings three remarkable perceptions to researchers' mind. First, the youth mobilized and attached universal values. The second one was that the UN Security Council reached the conclusion about a no-fly zone here, and the third one was that Arab League shaped up in an unprecedented way. But much more important is to see what are the real circumstances in the country. I have had the privilege already discuss with Mr. Musa and some other persons who prepared the new constitution, and I already have said that that is written on very modern, detailed way, and that will mean a great challenge in the future, especially for new parliament, I suppose. I will try here make some comparative studies, and actually my let's say the most important part of this lecture lecture will be rule of law, but I dare say some few words about constitutional reforms, of course. So let's have the first slide and start with this Constitution 2014. As I said, it is very detailed and divided into 6 parts and consists of 247 articles altogether, and some of these parts are, let's say, very interesting for outsider and also can mean some new steps in constitutional framework. We can have the next slide. This is part number 2, basic components of the society. There will be social components, economic components, and cultural components. And I think that presenting these kind of components, it is comprehensive manner, and the Constitution creates a great challenge in implementing them, because they are quite flexible ones. They are also some rights which are absolute. Every citizen has the right to healthcare, education. There will be independence of universities, but at the same time, they have been stated that the state shall allocate at least 2% or 1% on GNP, so that these kind of sections are quite flexible, but I understand them that is like priorities, just to take care of education, healthcare, and so how is the situation when the parliament is implementing this, or the government? That could be another story, and it depends on economic possibilities. Let's have the next. That is public rights. We call them fundamental rights in our constitutional thinking, freedoms and duties. This part is, of course, especially significant because Constitution, in my mind, is not only stated for institutions, state institutions, separation of powers and government. It is the basic norm of the whole society, and that is wholly important that these fundamental rights are already at the beginning of the Constitution. If we are thinking that civil society, ordinary citizens have to be like following the constitutional values and trust in using of public power, it's wholly important that fundamental rights are already at the beginning of the Constitution. In Finland, when we had our constitutional reform concerning fundamental rights 1995, we tried to write these sections, articles, so precise as possible, because it's one kind of problem if they are spaced to deviate, make restrictions of these fundamental rights. Like it is not good of constitution, it's not real, and you can trust that will be faulty. Therefore, I have no message, and I can not analyze this constitution moral or fundamental rights. I only can make some questions. One of these questions is that, for example, if freedom of belief is absolute, and the freedom of practicing religious rituals is a right regulated by law, it could be some problems in implementing these rights, but I really trust that after these discussions that it is a goodwill so that the restrictions will be so few as possible. But of course, this kind to write constitutional rights also leaves some space for deviation. Let's have the next slide. The legislative power, the House of Representatives. Unicameral parliament has been one of the, I see, the significant changes in the government system, and I very well know that it has been lively discussion. It would be two cameras or one camera, and I think that it's better to have this unicameral parliament because it will not leave some space for, let's say, complicated relations between president, government and parliament. Unicameral parliament is, especially from a citizen point of view, much more transparent than two cameras, which exist, of course, in France, in US, in Russia, in many countries. But anyway, there is not a federal system. That would be better to have a unicameral. Right. I hope that my conclusions are not too direct, because as a retired judge I dare say what I remember or what I think. Okay, the next slide. This is a government status of government and prime minister and other ministers. That is a question discussed very much in different countries. I have just been in Nepal helping them to make the last drafts for constitution. It has been discussed even in Finland many times. Who should elect prime minister? And as we see also here in Egypt, constitution is written that way, so that it is actually very much parliament which is in the position to be appoint the candidate prime minister. And already the constitution of 2012 so to balance the appointment of the prime minister, and now this has been preserved in Article 146 in the new constitution. But if you can, maybe you can see and read this, if the prime minister nominated by the president does not win the confidence of the majority, the president shall appoint a new prime minister who is nominated by the party or the coalition that holds the majority or highest number of seats in the House of Representatives. However, the president may also in this case, in consultation with the prime minister, choose the Minister of Defense, Interior, Foreign Affairs and Justice. This means that the President of the Republic still has very, let's say, a powerful position to nominate the government. Let's see what is the next slide. We might see so slowly to Finnish constitution, but let me before that say some conclusive remarks concerning the new Egyptian constitution, which I find, as I said, written on a very modern, detailed way. It will mean a challenge to the new parliament, which will, as I see it, legislature will have stronger status than before. And also there are many hopes, of course, going to the parliament, which have to regulate how the fundamental rights will be implemented. And one other thing, under this day we have discussed quite much also about judiciary and independence of the judiciary, and I've seen that judges are very independent in this country. That is very important, but in my mind also same time I have promised in some discussions here with people that I will speak out that independence does not mean any isolation of the society. We in that snowy Nordic country, Finland, we feel that judges are also serving people, and independence means also dependence to the law and dependence to the social development in the country. So that I do hope really that this positive step to have a new constitution will mean really that Egyptian nation goes forwards and these promises in fundamental rights will be fulfilled. Because these sections and articles I have written, they are very long-going and good fundamental rights, and even much more than in some other countries. You can maybe later on, I can say something. Yes, but okay, we go direct to comparative studies about basic rights and liberties in the Finnish constitution. As I mentioned, I've been in charge to reform the Finnish fundamental rights reform 1995, and our chapter number 2 concerning these rights and liberties, it's only, let's say, 15 articles compared with the Egyptian 42 articles concerning fundamental rights. But they are almost the same, but our tradition to write is like in snowy Nordic country. We write very shortly and we try to write as precise as possible so that there will be no marginal expression and interpretation in everyday life. You can maybe see that at least we have this equality, we have the rights to life, freedom of movement, right to privacy, etc. And I will not go through this list, but if you are interested, we can of course distribute later on the Finnish constitution to the participants of this meeting. One thing is essential at the end, that is protection of basic rights and liberties. We have very short section number 22. The public authorities shall guarantee the observance and basic rights and liberties and human rights. Every agency, public authority has this same responsibility to take care that these rights will be fulfilled. Next one. So we go slowly to government and position of president. Before that, I give you time to read that, say some word about the Finnish constitutional reform. Finland was many hundred years part of Sweden, and for over a century between 1809 and 1917, Finland was autonomy and part of Russia. Grand Duchy, we call that time. These developments and this period, they were not without any paradoxes, but the most important was that Finland could keep its own legal system, and that's why legality and the rule of law thinking is so deeply rooted in our country, because we have to defend our legal culture to East, to Soviet, and also to be independent from our old sister country, Sweden. So that is maybe the reason so that legal thinking is so deeply rooted in our country. When Finland got independence in 1917, we then got our first constitution. 1919, it's very close. The Egyptian constitution, it came 1923 or 4. Yes, 4. Our constitution at that time was drafted and adopted under conditions of heavy ideological and hegemonic crossing, so that we had also revolution, we had war, and we had all the problems what the nation would think about. And that constitution was really, we call it mixed constitution, because we had very strong ruler, status of president. It came from Swedish side as the old Swedish king, and then we had the first modern unicameral parliament in the world, already established a little bit before 1906. And these two power centers were in that constitution, and the government didn't actually play any role. And so step by step we could strengthen the parliamentarism so that the government was raising up a little bit and the president a little bit down, and the parliament would keep its position as the number one actually. From mixed constitution to parliamentarism, it happened 1999, and nowadays constitution is dated 1999 and practically adopted mostly. It was final vote was 175 for and 2 against. We do not have any referendums in our country. We do have them if someone will ask something advisory opinion, but this referendum system is not so known in our country. Compared with Egypt, you had already quite many referendums during last years. Our parliament is characterized by its unicameral structure and by its function as a multi-party forum for fundamental national decisions, and party pluralism is ensured by the electoral method with proportional representation and large electoral districts, 12 or maximum 80. That is also very important, how elect the parliament. And we so slowly come to the status of president. At the beginning, we Finns had no clear oversight of what the status and the role of the president would become. It was developed during decades, and until nowadays it was quite powerful, and of course still that, but more like respected for other reasons, not this formal power. This is quite interesting section, so that it means that the President of the Republic makes decisions in government on the basis of proposals made by government, and if the President does not in the matter do so, the matter is returned to the government for preparation, and if the government will keep that opinion, so the government may present to the Parliament a report on the matter, and thereafter the matter will be decided in accordance with the position adopted by the Parliament. This is not practiced in practice, but thank you. Can you hear my voice actually? I mean, this section has more like preventive influence. It makes the decision making so cooperative, so that President and government together will make the decision in principally important questions. I think it's something clever. It gives all the parties possibilities to make their own, but anyway, this is like the system always serves the cooperation in these matters. Duties of Prime Minister, that is also one of the key questions, of course. Our government is quite small. There are only 70 ministers and 13 ministries, and the government exercises general authority in the broad field of state administration. In other words, it is competent to deal with all matters that have not been specifically reserved for the President or another public authority. That means that the government is the general activist in state matters. Please. So slowly I go more to juridical use. We do not have in Finland any constitutional court, but we have an innovation that means, and that's called primacy of constitution. That means, and if in a court of law, especially in Supreme Courts, in concrete case, we can find that application of ordinary law is in evident conflict with the Constitution. We set these ordinary acts, law on side, and directly apply Constitution. This is also the system in Sweden, Finland, Sweden, maybe the only ones, and it means actually that every citizen can trust that in my case, anyway, the Constitution will be followed, and it has also meant that Constitution has come quite close to the civil society and ordinary citizens, so that it's not like theories they are also applicable norms. Maybe I jump over, if we don't have any, let's see, no, we don't have not more about Finnish constitution. I will only say that during last decades, when drafting the new constitution in Finland, we have done that step by step. The first reform was made 1987. You can see almost 50 years without any amendments, and then we made quite many amendments, reforms in the constitution. But all of them have been made step by step. Quite small steps, but so the result is Western countries, parliamentarian constitution, and so method has been like we used to say in the Nordic countries. We are quite slow people. We go without any positive things, any negative things, but the development goes within us very slowly. Okay. So, ladies and gentlemen, I have an idea to tell about the prospect of rule of law. You might ask, like the students yesterday at the university, what is rule of law? Because even we are quite familiar with the principle of rule of law, it's not easy to find any unified concept, because they are countries. Rule of law is, well, very traditional. They are some countries where is it very normative, constitutional. We can see differences between the Nordic pragmatic, American, federal, liberal, British, parliament-oriented, without any written constitution. We can also see Chinese legal thinking, Confucius, hierarchical philosophy, and Russian democratic, federal governed, what is to be researched, and African poverty and instability related systems. Let me see some few words, and if my presentation is too long and boring, just to interrupt me so I can stop. Let's have a very short trip. I invite you to trip over the whole world. And the first object country is, of course, Finland. Very small. Role of teacher is unknown in our country. Like I said, because we have learned much when we have been traveling in other countries. In European Union too, we have different concepts of rule of law. As I already mentioned, Germany, the biggest, largest member state, they have a development which is characterized by constitutionalism and emphasizes the constitution, federal structure, and that is quite complicated for many outsiders. We have England, UK has no written constitution, and US, I would say some few words. The legal development has been influenced by liberalism, of course, at the beginning, as a counterbalance to the old European aristocracy. But nowadays, with the terror attacks of September 11, we can maybe analyze that as a security-oriented rule of law. They are not so much liberal thinking left instead of more and more check and security issues. In Russia, that is in very interesting stage now, after collapse of socialism towards a state by law, there are many reforms made. The law stated 1993 is very much like Western countries, but the legal culture and the circumstances are wholly different. Mr. Putin has himself also said, when some journalists asked him what is the rule of law situation now in the country, that there is maybe, unfortunately, there is no response from civil society to us, to government. And I think that civil society plays relevant role in all the countries, but especially nowadays in Russia, in our neighboring countries. In China, maybe many of you have been in China. I've been there already 17 times just to have some lectures and writing some books. China has interestingly, consistently progressed towards openness since 1978, and every 5 years they have made some reform. 88, there was possible to supplement the public economy with private economy. The concept of social market was introduced 93, and the goal of constructing a state ruled by law was set in 99, and 2004 also protection of private ownership and respect of human rights. What does it mean and how they are implemented? That is another story. Now these days it's very actual questions in China because the Communist Party just has decided of a reform program that shall mean reforms for all the sectors and make the distance between government and economy a little bit smaller. On the African continent, the development of the rule of law is hindered by unstable conditions and poverty. If you go to the South Africa, you can see that there are many colonial traditions, and that is the question if civil law system or common law system would be better for rule of law. There are some researchers who found it that it's not a system actually. Education and the possibilities to receive information are much more important. Or is it civil law system or common law system? So you see very short slip that it's difficult to identify a single rule of law concept. And that's why I dare tell about my innovation. It's not a new concept, but I've been thinking how to find more pragmatic concept of rule of law, which would be understandable for citizens and in different countries. And I found this metaphor so that rule of law or development actually of rule of law is like a house built on solid ground This solid ground means basic values, religious, cultural, anyway, basic values in the country. And like a house, also, not yet. My wife advised me already. This house has, or rule of law concept also, 4 corners. One is, of course, legality. All the using of public power will be bound by law, under the law, strict under the law, and regulatory policy is in key position. The second one is separation of power, not as theory, but balanced relations between institutions, as seen in constitutions. And the third one is human rights, respect the rights and duties of citizens, because it's easy to say that in every good house are living ordinary citizens, so that it's most important to analyze the house from citizens' point of view. So fulfillment of the rights and duties. And the fourth corner, what is problematic in many Western countries, is functionality of the house, delay, and so on. So we will see. Yes, next one. We will very shortly, I try to be short, analyze these four corners. This is the first corner, legality. Of course, constitution, parliamentary acts, contract standards, but more or less nowadays also soft law instruments. For example, in China they are using very much soft law because their state exact these new requirements by parliamentary law, and the market rules are mostly soft law, lex mercatoria, etc., and many standards. So actually in this corner it's most important to keep this hierarchy of norms, especially the constitution will be the basic norm for all these other steps, and regulatory policy. Separation of powers we discussed already quite much, but I see that status of parliament and selection of its members is in key position. And then of course parliamentarian system needs government and governmental trust, and then of course independence of the judiciary. In many countries I have noticed that independence of the judiciary is quite problematic, so that judges are afraid to make decisions if they really are not independent. But as I said, independence